Okay, good morning, ASHA and CCSA members. Welcome to our third collaborative OHS discussion forum. I'm going to give 1 minute for all members to join us, and we will start the presentation and discussion. I can see the number is rising for the participants. So yeah, we'll start the discussion in 1 minute. Okay, as I see the numbers are going up, let's start to do some platform housekeeping, and then we will start the presentation. So my name is Anush Gunashan. I'm the Education and Resources Coordinator with ASHA. We have Dana and Nadine from CCSA and guest speakers that will present shortly from WCB. And so before we begin the presentation, I would like to quickly let you know how the platform works. We request that you post all your questions in the Q&A box and add only comments in the comments box. So if you have any questions, please post them in the Q&A box. We will answer them in the order we receive. If you would like to speak to us, to ask questions to our presenters, please raise your hand and we will unmute your microphone so you can talk to us. So you have a few options. You can talk to us or post your questions in the Q&A box. Please make most of it, ask any questions you have. Even if we don't have answers, we will do our best to get back to you later after the forum. And so again, if you have any technical difficulties, please send us a message or try to contact our office. Our admin team will try to help you. Now, let's move to our today's agenda, and Dana will present the agenda.
Thanks, Anush. Thanks everyone for joining us again today. I see a lot of familiar names. If you'd like, take a moment to introduce yourself to the rest of the attendees in the chat box. Today's agenda, we're going to have the Employer Appeals Advisor Branch present, and that'll be Brandy and Tom. I'll introduce them shortly. Then ASHA is going to present some of their information. CCSA has a couple of pieces of information, just short pieces of information to share with the group today. And then we'll move on to the wrap up and evaluation. So if we would like to move on to...
Yeah, now let's welcome Brandy Madison.
Yep, so I think we have a slide for her. So Brandy, I don't see it moving unless
Tom, can you present the slide?
So I'll introduce Brandy. I'm really excited to have Brandy and Tom present today. We had scheduled Brandy to be at CCSA's AGM in April, and that unfortunately was postponed. So really excited that Brandy and Tom were able to join us today. Brandy brings to the Employer Appeals Advisor Branch a wealth of knowledge and experience garnered over a long career with the Workers' Compensation Board of Alberta. Starting as a claims adjudicator in 2006 with WCB, she had different positions, including case manager, claims resolution case manager, and appeals advisor, prior to joining the Employers Appeals Advisor Branch as a branch manager. Brandy worked in WCB account management, handling employer appeals, where she honed her skills as an employer advisor. This experience provided her with a platform which she will deliver superior services to employers. As a manager of Employer Appeals Branch, she leads a team of employer appeals advisors and works with key stakeholders to provide appeals services, education, advice to employers on the WCB system. And next, I'd like to welcome Tom. Tom Curran is a appeals advisor with the Employer Appeals Advisor branch. He has a wide array of experience and knowledge from both the private sector and a 10-year career with the WCB. In the private sector, Tom garnered considerable experience with operations management, employee recruitment and training, leadership, regulatory compliance, and financial stewardship. In 2009, Tom joins WCB. During his time with the WCB, he held positions with employer accounts, underwriting, and the Office of Appeals Advisor. With WCB, Tom had significant experience with operations management, leadership and project management, employee training, quality assurance, and the application and interpretation of applicable legislation. As an appeals advisor with the Employer Appeals Advisor branch, Tom advocates for employers with issues they experience with the WCB and the system partners. His duties include representing employers throughout all levels of the appeals process, performing comprehensive case reviews, providing education and advice, and performing employer and key stakeholder outreach activities. Welcome, Tom and Brandy, and I'll hand it over to you.
Thank you. Thank you for the introduction. Welcome, everyone. I see that there's 33 people, or 30, maybe 36 people, which is great. The more that people can hear about our services, the better. I am Brandy Madison. I'm the manager of the Employer Appeals Advisors. And we're really glad to come and speak with you about what we do, because we think that it's essential service for employers. And you know, WCB can be a very complex system, and we're here to help. So go ahead to the next slide, Tom. So one thing that we are is we're actually not from WCB. We are with the Alberta government. We're currently with the Fair Practices Office. And so we are independent of the WCB, which means that, you know, when you come to us, we can give you independent, expert, and free of charge advice. So depending on your needs, that's kind of how we tailor our services. But it's really important that we note that we are independent from the board, and so they don't have any sort of hold on what we tell you. We can be, you know, real advocates for the employer, because we're not staff of the board. We're currently with the Fair Practices Office, and as some of you may or may not know, there was recent legislation that came into that was proposed, and that we go underneath the Appeals Commission. So the services are still going to be staying. It's just how they're carried out is going to change who we're under, but we will still have Employer Appeals Advisor services. So when I say that we're experts, all of us have worked for the WCB in some capacity. So my team is compiled of people that have, like, I think we have altogether 30 years of experience combined within the system. And so there is nothing better than people that have worked in those jobs to be advocating for employers, because we understand the ins and the outs of the system. You know, if you haven't worked there, you don't know, you know, why they make certain decisions or what they're telling their people. And, you know, based on what we're doing now, we still get information from them because we work with them as stakeholders as far as, you know, any sort of policy changes we can put in, you know, input into that kind of stuff, just like employers can. And so we've all worked through the claims, we've handled them, and Tom specifically has worked on the employer account side, and so he brings that specialty to our team, and the other folks have been claims managers. It's free of charge. So, I mean, we always like to be careful with this statement when we're saying that to employers, because we're not naive to the fact that, you know, our services are obviously paid out of the accident fund, which, you know, employers do pay into, you know, that's made up of employer premiums. So, but when you come to our office and, you know, request our services, there's no charge to that service. You're not going to be handed a bill at the end of it, you know, like a lot of other representatives do. We don't charge you for the service. So it's, you know, it's included within your premiums, which I think is, you know, even more of a reason to utilize it. Go ahead, Tom. So the services that we provide, so we provide advice, education, and representation. So when we're looking at advice with larger employers, typically they have, you know, a safety person or somebody that's specialized in WCB handling of claims. So with them, we're gonna work in conjunction with each other. So we're going to provide advice, we're going to share knowledge. You know, larger employers will call and say, we're stuck on this, we're not sure what to do, can you help us? Or, you know, this is happening, can you provide us some advice on that? So this is, WCB does have an internal department that also does advice. However, they can't take sides, where we can take sides. We can tell you, no, this is unfair. The employee, you know, this is what you should do, X, Y, Z. And we're also going to send you a letter at the end telling you exactly what to do. We base that service on the knowledge of the employer. So if the employer has lots of knowledge, then we expect that they're going to go and carry on the appeal on their own. We've also done train the trainer type things. You know, there might be, the employer might have safety people, but they're not familiar with WCB. They're not expert in appeals. And so we'll, you know, per se handhold them through the process, you know, kind of teaching them, and then hopefully they can do it, because our services are for, you know, the smaller employers that don't have any sort of knowledge. But we do have advice and, you know, we don't do formal representation with very large employers that can hire people to do that job, but we're always there for advice for the larger employer. So education. So a lot of times employers will come to us and say, you know, Brandy, this guy wasn't wearing his boots, his steel-toed boots, and he got injured, and why is that our fault? And, you know, unfortunately, or fortunately, I guess, for workers, is the fact that this is a no-fault insurance, you know, and some employers don't understand the fundamental principles of the fact that it is no fault. And so whether or not Johnny was wearing his steel-toed boots, it doesn't matter if he's hurt on your work site. And, you know, it's up to the employer to make sure that their staff is coming prepared, and, you know, and so we're going to educate on, what does legislation mean? What does this mean in this situation? You know, a lot of times, even though a claim is accepted, the employer still has questions that they're not understanding. Why is it that they're paying this person? You know, and so we can educate. If we see that, you know, actually this person should not be paid, there's no evidence to support that, then we can also direct you in that way. And then finally, we provide formal representation. And so what that means is, you know, we'll get the claim file, we'll review it, we'll offer, you know, we'll meet with the employer and let them know what we think, and we will take it through the appeal system. Our first and foremost idea is to resolution, right? We want to get resolution before we move to the formal levels of appeal, because the appeal process can take a long time. And so if there's anything we can do in order to get the issue resolved on the front end, we're going to work hard to do that. So that means, you know, working with the case manager or the customer service supervisor to try and get that resolution for employers. If we can't do that, then we will take the claim to the first level, which is the DRDRB, the Dispute Resolution and Decision Review Body, and that's within the WCB. And so we will, you know, do a presentation. We will be there on behalf of the employer. We still ask that the employer attend in case there's additional questions. And we're working very closely with the employer on this, because this is, at the end of the day, the employer's appeal. It's not ours. And we want to make sure that the employer's interests are being put forward in the appeal process. So if we're not successful at the DRB, then we'll go to the Appeals Commission. The Appeals Commission is the most formal, informal process I think I've ever been to. They say it's informal, but it's actually pretty formal. So, you know, you're presenting in front of three panel members on, you know, they're part of the commission. And so for employers, that can be pretty intimidating. And being that I used to work as a workers advisor, I've went up against a lot of employers. And so I think that that makes me a better employer advisor, because I know exactly, you know what, maybe we don't go there. We don't say some of these things. And so I know how to navigate that panel because of that experience, because I think it's really important that employers are educated in these processes, because it's essentially like going to court. And so what the advisor will do is they will act on your behalf. And then if there's any questions or anything that the employer wants to put into those hearings, then they'll be allowed to do so at that time. So with that, I will turn it over to Tom.
Excellent. Okay, thank you so much. And so I'm Tom, and work with Brandy, and thank you so much for having us. So moving forward, I guess the first thing I want to talk about is the top 3 issues that we see. And it's interesting that this is, we've been doing this now for this particular office for a couple of years, and the list has remained fairly constant. So the top 3 are the claims acceptance, there's cost relief, and then there's wage replacement. So this is the part of the presentation that I kind of like, is that I get to give some examples. So I get to talk about some real life claims that we've dealt with. So claims acceptance. So there was one where the worker was, she works in an office, and she was at her desk, and now prior to any of this happening, she had some mobility issues with her hip that required her to walk with a cane. So anyways, so she's at her office, she prints a document that she needs, and she's walking from her desk, from her office to the common printer. And, she has to walk down this hallway, and unfortunately she trips over her own feet. So the key point is she tripped over her own feet. She didn't trip over loose carpet. She didn't trip over a computer cord. She didn't trip over an extension cord. There was no, holes in the carpet, nothing. The whole area is pristine. And she tripped and she fell. And unfortunately, she suffered some hip injury. And I think in fact, she needed some sort of hip replacement as a result of it. But the problem was WCB accepted the claim. So the employer came to us and said, well, normally there has to, like, how is this fair? Like this person, although we feel bad that this person got hurt, it wasn't from something that work did. Like, and I agreed, right? Or we agreed in that, well, if there was a loose computer cord or something like that they tripped over, fine, then it's an acceptable claim. But because there was no employer-related hazard, we were able to show to WCB through the appeal system that this shouldn't have been an acceptable claim. So the good news is WCB's decision was changed and it had no impact on the employer, which was great. In terms of cost relief, so cost relief in its simplest form means that the cost of the claim doesn't impact your account. So we had a claim where a gentleman worked for a forestry type company, and he fell off of the back end of a trailer. And the fall was a very minor fall. It was about, I want to say it was less than a foot. It was 6 or 7 inches that he fell. And he suffered a bit of a physical injury. He hurt his back and hurt his shoulder. So the physical side of that injury resolved within, I would say, it's been about 2 or 3 weeks that it resolved. But the person actually didn't go back to work, or hasn't even still gone back to work. And we're talking almost 2 years later now. And this person had some, unfortunately had some psychological issues that prevented them from going back. And we were able to, now the cost of this claims was, by now I'm sure it's approaching $200,000. So we were able to show that this worker had some pre-existing issues that were outside of work that prevented them from coming work. And as a result, all those costs got removed from the employer's account, which, as you know, at the end of the day, affect the premiums that you pay. The last one there that we have is wage replacement. So this is where, one of the things that WCB pays aside from the medical benefit is they pay somebody's wage while they're, on claim. So I think the last time that I visited with the CCSA last year, I might have brought this one up where a gentleman, he was already on modified work. So he was a heating HVAC person, so heating, ventilation, air conditioning. And he got hurt doing his job and he was on modified work. So his employer sent him to a customer site to go fix an air conditioner or something. And he finishes the job, and this is where it gets kind of interesting, is he finished his job and he had to, how do I put this politely, relieve himself. And rather than walk back into the shop to use the washroom, he decides he's going to go on the outside of the customer's building. So the customer's video camera catches this. And of course, the customer, like any customer, is incensed. And they call the employer and say, you know, what the heck? Is this how you treat your customers? And the employer, of course, does what any normal employer would do and terminates him. So I grant that if I ever went to an employer site and did that, Brandy would get a call and I'm sure I would be out of a job real quick. Now, the problem is WCB policy around modified work has blinders on. And what it says is all it looks at is who removed that modified work. If the employer removes modified work, then the employee is entitled to full wage replacement until such time as that they are deemed fit for work. If the worker approves of modified work, then they're not entitled. So WCB put their blinders on and said, okay, well, the employer removed modified work by terminating this person. So now this person is entitled to full wage replacement. So of course the employer is also very upset, saying, well, hang on a minute, is this saying that the employer can do whatever they want, or the employee can do whatever they want and still get wage replacement? So our argument was, well, that's never been the intent of the act. Like, are we saying that if I'm savvy enough worker and can figure this out, I can go, you know, assault my boss and then still get wage replacement? I think we can argue that, you know, the framers of the legislation didn't intend that. So we have some finality with this one now. So the unfortunate news is we lost the battle. So the appeals commission did say that, well, unfortunately, all policy says at this point is who removed modified work. The employer removed it, so this worker is entitled to wage replacement. But I have a piece of good news. So Brandy alluded to the new legislation, Bill 47, which we will get into later. But basically what's happened is if everything goes through, then we're going to win the war, because WCB is changing the policy and they have a new policy specifically around egregious behavior of a worker. So if the worker does something like this in the future, then the employer has the right to terminate them and they won't receive their wage benefits. So it's great in that regard. And we'll get a little bit more into that a little bit later.
Sorry, Tom, for interrupting you. There is a little bit of noise in your microphone. Would you mind setting, just try, yeah, maybe let's try.
Is that a little better?
I think so. I'm not sure what others think, but I think, yeah, the noise is gone now.
Okay. Okay. Moving on then. This next slide talks about, so this is a little bit of the economic advantage of engaging our office. So, you know, being employers, above all, you understand that time is money. So what we're saying here is by engaging us, at the end of the day, you are saving, you know, there's a bunch of savings in time. So the first little bit here we talk about is, well, it takes, you know, approximately 3 days for us to complete a good file review. And we probably spend another day or half a day with discussions with WCB. We probably spend another couple of days working on some submissions. And then another probably 3 days doing the actual appeals commission sort of presentation stuff. And then, of course, there's the attending the hearings, which takes a day. So all total, you're looking about 9.5 days, or, well, let's round up, 10 days. So 10 working days. So 2 weeks, 2 full weeks of someone from your office, you know, focusing on whatever their core tasks are, as opposed to doing this. So, that number can really add up. So you think about 2 weeks per file times whatever that person's, wage rate is, it can really add up to a lot of money. So that's another sort of great benefit of engaging our office to help you with these kind of situations. This one is a bit of our metrics slide. So those of you that are into metrics and performance stuff. So this is what we deliver. These are sort of the hard numbers that we're able to deliver. So what we commit to do is once a file is assigned, we commit that you will be we'll be in contact with the person within 5 business days. We will then order the claim file from WCB and receive that within 10 business days. And then within 30 business days, we will have sort of reviewed the file and come up with an action plan. So that's where we say, okay, this is where I think we should go, and this is what I think we can try, and maybe we avoid this, but we bring this up. And it's important, and I think Brandy could probably speak a little bit more about that, but I think we hit that pretty much all the time. I can't think of, there's always special circumstances, but I think we've been very successful with hitting our metrics. And it's important that we say that, so that, you don't think, well, I've hired this person, but I haven't heard back from them in 60 days, or I don't know what's going on, right? So we kind of keep you sort of in the loop throughout the whole process. Okay, next one is the common types of accidents. So what we did is we pulled actually the accident statistics from WCB specifically for the industry codes that you both support. So with the continuing care and the Alberta, the seniors housing, so the 2 industry codes there. So this shows that the 4 different types of the 4 most common accidents that you have, and then it also shows what the average cost per claim is. And you'll see right at the bottom, the number one is falls, and that has a claims cost average of about $6,800, which actually works nicely, because I remember seeing in somebody's email tagline, Fall Prevention Month. I'm getting a few nodding heads. So yeah, so it's great. So it sort of validates the fact that, hey, we need to spend time on, obviously falls are common in our workplaces and they cost $1,600. So, what can we do to help alleviate that? Another one that kind of jumps out, and it's one of the smaller ones, but this one at the very top where it says assault, violent assault, and harassment. And that one is just over $4,100 is the average cost. And right away, to the first person, like, what's happening? Are people getting into fights or dust ups here? And looking at the type of work that happens within your employers, that I would surmise that it's coming from, when you are probably helping to take care of a patient who maybe suffers from, cognitive issues, dementia, and those kind of things. And sometimes they can be combative. So, basically at the end of the day, what this slide does is it illustrates these are the things that you're facing, and maybe these are the things that you can sort of focus your resources on. So like I said, you have something about Fall Prevention Month, maybe you start to look at, or I'm not sure, obviously you probably are already, but how you can sort of limit some of these other things. These are just sort of, general ideas. If you haven't before, I highly recommend you go onto the WCB website and pull statistics specific to you as an employer, because it gives you a lot of great insight, right? So you don't know what to fix unless you have sort of a roadmap to get there, right? So WCB is sort of good with that kind of stuff. The next thing I want to talk about is the most common types of injuries that are happening within your groups. And number one, and this is common actually throughout all WCB industry, is sprain strain. So, back sprain, shoulder strain, that kind of stuff, right? That happens quite a bit. The one that really jumps out, and because it's really in vogue right now, is that one at the bottom, COVID-19. So to date, there's been 203. And I guess first off, based on the work that you all do, being frontline workers, thank you for the stuff that you've done, like to help take care of our loved ones and the support that you provide. So on behalf of myself and all Albertans, thank you. So anyways, with COVID, so we have right now about 203 of those. The thing with that is, obviously you're exposed and you have all of the, the proper PPE and whatnot. But I think the thing that in my mind, that might be something to look at is down the road, the psychological impacts of that. So, maybe you start to work with your EFAP providers or whatever to help sort of alleviate or to help with those, because, obviously we're still in the early parts of COVID and we don't know what's going to happen sort of down the road. We've seen some encouraging news just last night. There was the thing on the news from those two, Pfizer and Moderna, about the effectiveness of their vaccines. And, hopefully that comes into fruition, but, we just don't know the long-term impact. So I'm going to think that there might be some psychological stuff that, maybe we want to get in front of. Okay. So speaking of pandemic, so in September of this year, so just a couple of months ago, WCB announced their cost relief plan for claims impacted by the current pandemic. So first off, there was that provincial shutdown from March 16 to June 12. So, and then basically what that deals with is if, you were ready to bring someone back to work and because of the shutdown, you couldn't. Now, I don't know if that necessarily applies to you because you guys were considered critical service or first responders, so you didn't shut down. So that probably didn't impact you as much as the shutdown part. But what happens if you had, workers coming back from, they're coming back from modified duties, or they're coming back or trying to start modified duties in the middle of the pandemic? Another piece of legislation or part of this is that the workers' benefits won't change. So basically what this is allowing you to do is, so the workers' benefits will stay the same, but if you meet certain criteria, it'll allow you to apply for cost relief. And there are 5 different types of claims that allow for cost relief. And basically it deals with around the shutdown. So if people were to come back during the shutdown, or if it was direct result of the COVID, like someone contracted COVID as a result of their work, WCB has a system in place where they will automatically relieve those costs for you. The piece of advice I would give is it's great that WCB is saying that they'll automatically do it, but there's a sort of a saying that's used in sort of the audit circles of trust, but verify. So if you've had someone who's been on claim and that's been on as a result of this COVID stuff, and WCB said it's automatically going to be relieved, well, just maybe make sure in the background that that's actually what's happened, right? Because, they're humans and mistakes can happen, right? Okay. Next thing I wanted to talk about is the Bill 47. So Brandy had alluded to this a little bit earlier. So this is now it hasn't, it's being debated by the legislature right now. So it hasn't officially passed yet. I can't see, based on the government makeup as it is, I can't see that it wouldn't pass, but nonetheless, it's still not law. But if it goes through, a number of things are going to happen. First thing, number one, is on or before April 1st of 2021, the Fair Practices Office will be closing. So the good news, though, like Brandy had earlier pointed out, is the appeals, the advisory services are going to be moved to the Appeals Commission itself. So the intent is that our service will still be available. It'll just be under a new organization. So I'm sure the name will change, and maybe the business cards and all those kind of things will change, but the service itself will be the same. Another piece of part of Bill 47, there was a number of things being proposed to change to WCB legislation. So a few exciting things for employers. First one is they're removing the presumption on psychological injuries. So when stuff was last changed, basically it said is if you had some sort of event attributed to work and you had a psychological diagnosis, then automatically it was assumed that it happened from work and became a WCB accepted claim. So as a result, psych injuries kind of really went up. So now the government is righting that ship saying, well, we're going to remove that presumption. So now the only presumption exists for first responders. So, you know, your fire, your police, and your ambulance people. But for everybody else, that presumption has been removed. Another positive change that we feel is, excuse me, the duty to accommodate. So the last legislation came through that said, well, when a worker is hurt, the employer, as long as they don't hit certain criteria, the employer has to bring the worker back to work and can't let them go. The problem is that created a lot of hardship for a lot of workers or for a lot of employers, especially in this economy being, you know, a slower economy. So now that duty to accommodate is going to be removed. Now, that being said, there still is as an employer, there still is a financial incentive for you to bring workers back to work, because if you can lessen the lower the claim cost, the better that your potential premium will be, right? So there's that sort of benefit. Another piece of good news would be there was a requirement under employer health benefits. So if an injured worker, you had to, if they were away from work, you had to continue to offer them benefits for 12 months post-injury. So that created some problems, because those of you that have worked with those benefits know that it's not easy changing people in and out of those benefits. And sometimes, depending on your contracts, sometimes you're not allowed to have people who aren't actively participant. And I know of cases where employer had to fudge the truth to include them. And now that is going to be removed again, so that the employer no longer has to do that. Another great piece of news is something called surplus distributions are coming back. So in its very oversimplified form, surplus distribution was, so as you know, WCB is fully funded from you employers' contributions from your premiums. So in a very oversimplified way, when WCB had too much money, they gave back money to employers. So then the policy changed that, well, no, that money is being held for workers, so you don't give it back. So now the new proposal is the surplus distribution will be coming back. So, you know, potentially that could, you know, have some money coming your way. Now, I don't think it's going to happen for this year because, well, there has to be extra money to go back. And this year being the most interesting of all years ever, I don't think that's going to happen. But the good news is it's probably going to happen for future years, right? Depending on the performance of WCB. The last thing is there's been some changes to OHS legislation. Now, Brandy and I are not OHS experts, so I can't really get too much into this. All I can really say is they put forth some changes about requirements around health and safety meetings. And that really meant, I know that it really impacted like oil and gas and construction, about when you had a job site with multiple employers on fact, and they had some requirements on how these meetings had to be made up. So they've sort of changed those requirements. The best piece of advice I can give you on around that is, you know, engage your OH&S personnel and your health and safety people, because they would be sort of more attuned to what those changes actually were. Okay, moving on here. In terms of future engagements, so, you know, again, thank you so much for inviting us and having us present today. You know, we're hoping that you can present, you know, pass on our information to your members and, you know, potentially down the road, integrate us into your, you know, your websites or your promotional materials and, you know, tap into your communication systems. And I know that we're happy to attend these whenever you have the chance to invite us. But basically, the more that you can sort of get our name out there, the more that maybe your membership can engage us. And I think that being said, excuse me, as it exists, here is our contact information as it stands right now. When things change, of course, I'm sure that stuff will change and we will sort of keep you up to date. But I think that sort of wraps up what I wanted to present today. I'm not sure how we open this. I'm sure you guys can tell us how we open this up for questions, but thank you so much for having us today.
Thanks, Tom. Actually, there are a couple of questions in the chat box from Jonathan. I'm about to prepare 2 appeals for claims. Should I be talking to you first?
Yeah, I can answer that. So we would definitely recommend that. I mean, if you're preparing an appeal, we can kind of just guide you and make sure that there's actually merit to the appeal. That's one thing that employers have found very beneficial, is the fact that they can come to us and say, this is what we're thinking. And, you know, if there's merit, and in our experience, we've seen that be successful, we're going to tell you that. But if there's no merit, we can also tell you why. So that way employers aren't wasting their time if, you know, it's something that really, I mean, based on our experience, there's also, we can show you resources of where we find information on what has been appealed in the past and the outcomes of those decisions. So I would say that, yes, definitely engage our services for help on those appeals.
Thank you, Brandy.
And the second question was from, Jonathan had a follow-up to that. So he asked, does that start with a phone call, or do you have access to the WCB info?
So basically what happens is you can go online. I can also leave my email in the chat. I think I can access the chat, can I?
Yeah, you
Yeah,
can.
so I can leave my email in the chat, and I can send you an intake form so that you can bypass all of the initial kind of, I mean, I'll send my email, and you can fill out the form that needs to be filled. And so we don't have direct access to the WCB information. So if you have the claim files, we ask that you send them so that we can bypass that. And then it doesn't take the 10 days for us to get to the file. But if you don't have the file, we can request it and get it.
Okay, thank you. And then Gail had a question regarding the chart that you showed with the types of injuries, I believe it was, types of injuries chart. It went from 2015 to 2019 with COVID hitting Alberta in March of 2020. When does this report go to? So when would you have run that report?
Well, the report we pulled was, it was technically 2015 through current. So when we pulled the report as of, I want to say a couple of weeks ago. So,
So the 2020 information would have been current up until the date that you ran the report, essentially.
Yeah.
Are there any other questions?
I just would like to remind our members, if you would like to ask directly your questions, you can raise your hand and I will unmute your microphone. Alternatively, you can type your questions in the Q&A box or in the chat box. And while we are waiting for questions to come, I just want to run the first poll.
So we are interested to hear whether prior to today, were you aware of the employer appeals branch? The 3 options are yes, you've worked with them, yes, but you hadn't accessed their services, or no, you hadn't heard of them.
Okay, we now have over 72% participation, so I'm going to end polling and share the results. So we have 71% saying no, and only 29% saying yes, but I have not accessed the services. So,
wow.
Yeah.
Well, I'm really glad that we're here then to tell you about it, because it is, I look at it, it was an essential service for workers and an essential service for employers that was missing from our system for a lot of years. Employers have been asking for similar type services to what the workers had. And, you know, it wasn't until the last Bill 30 that came out where employers actually got it. So I was so happy when Bill 47 came out, where employers still are going to have the service, because it's essential. They're the things that we see from employers that they just, I mean, this is not the meat and potatoes of their business. Like, they're there to run a business. And WCB stuff, they just, there's just lack of understanding, which of course it's not their expert, that's not what their expertise is in. And that's why we're here to help and guide and, answer those questions that, sometimes you just can't get from the board.
Yeah. Absolutely. So yeah, I'm very happy that you were able to be here as well, Brandy. And we'll have to make sure we stay in contact when you get your new information so that we can get it posted on CCSA's website.
Yeah, for sure.
And continue to communicate the importance of the work that you do to our members, for sure.
Okay, we have another poll and I don't see any other questions coming. So let's run this poll too.
So we, it's kind of timely with the information that you shared in your presentation, Tom, about the COVID related claims starting to go up, and the thoughts that you provided around perhaps downstream claims as we kind of get past this and fatigue in real life tries to get back to normal. But we wondered, has your organization experienced an increase in accepted COVID-19 related WCB claims? And the three answers are yes, no, or unsure. This question is in part, we're starting to hear a bit of this from members in our industry. And so we are looking to prepare a response to WCB, to the president about the acceptance of the COVID related WCB claims, and whether, particularly for our industry, because it's definitely going to be the hardest hit.
Okay, so I'm going to end polling. We have over 75% participation. So here is the result.
No, most are not yet.
Yeah, 88% no.
Okay, that's very interesting.
Yeah.
Excellent.
Okay. Moving forward, so seeing no more questions, I would like again to thank Brandy and Tom for your presentation. I think it was very, very valuable. You shared such great information with our both ASHA and CCSA members. And I would like to let everyone know that the session is being recorded. So if you would like to share with your coworkers the presentation, we will be happy to share in the recording with you. And seeing no more questions, I would like to move forward to our quick presentation about occupational health and safety and ASHA initiatives, and then what we have come up and how CCSA can help us to meet the members' training and other occupational health and safety needs. So in 2019, ASHA received an occupational and engagement grant. And with this grant funding, we prepared 4 occupational health and safety tutorials. And we delivered the tutorials via our learning management system, which is called the Learning Center for Seniors Living. The topics were on harassment and bullying, hazard assessment and control, employees' rights, and working alone. After releasing all the tutorials, we have conducted a member survey. And as a result of the survey, as you can see, the members who participated in the training indicated that the training really helped them to adopt occupational health and safety practices within their communities. It helps them to increase OHS awareness, helped with overall health and safety performance, and help them also to comply with standards. And then after measuring the impact the training has had on members, we have also asked about the training gaps that was identified by members, what they need help with, and how we can work together with CCSA to address those gaps. So as you can see on the screen, conflict resolution and respect in the workplace was number 1 identified gap. They were asking, of course, more OHS and training on workplace inspection, investigation, and leadership training, core interview preparation, and then more training on violence in the workplace and emergency response, And then there were also requests to ensure that the TLC training meets the core requirements. So one clarification, while ASHA really tries hard to provide as many member services as possible, to trying to help members with their overall operations, it is CCSA's mandate to provide occupational and health and safety training. So with all of these things, Dana, I'm not sure what your thoughts are, and members, we welcome really your thoughts. Please share with us how you think we can address these gaps, how we can ensure members can access all the resources that ASHA has, that CCSA has, how we can help you meet all these gaps. And Dana, I welcome if you have any suggestions, please.
I'm not muted. No. Absolutely. These gaps are things that we're interested in hearing about. We do have an industry advisory council that we struck this year, which is working with members of the industry to identify what are the needs of members and how do we best meet all of those needs. So this is information definitely we can take to our industry advisory council subcommittees. We do have a subcommittee working on training and curriculum, and we have a second subcommittee working on the certificate of recognition. So definitely this is information we can take. We do have a variety of, I can talk about the training that we have currently. We have, over the course of the last couple of years, been developing a series of free on-demand webinars. I believe that link is now available to the OHS 101 for Leader webinars, which provides good basic health and safety information in a webinar format, on-demand webinar format, that the timing of those particular webinars range from anywhere from about 3 to 5 minutes to up to about 10 minutes. That's as long as they take. And they basically provide you with a good high-level overview of what's required from a health and safety perspective for things like hazard assessment, investigation, basically all the elements in a certificate of recognition program or in a well established health and safety program. We also, in response to COVID-19, moved all of our health and safety training, or the vast majority of our health and safety training, online into a virtual instructor-led environment and reduced the cost for those training services. So that allows us to be a lot more flexible with the training that we deliver. So all of the workplace inspections, incident investigation, our 3 safety leadership modules, health and safety committee, hazard assessment have all been moved into a virtual online instructor-led environment. We also, in our webinars, have a violence and harassment webinar for supervisors and managers in continuing care. So that's a free on-demand webinar. It's about a half an hour long that you can take. And we're currently developing other webinars, such as moving our harassment and bullying in service into a webinar format, and in addition, our mental health and wellness. Next steps were to look at some employee OHS 101 for frontline workers and develop a series of training events that way.
Okay, thank you, Dana. And sorry, I just have one question. So, and I have limited information about CORE. So because members were asking about CORE requirements and preparing for CORE interviews, is that something you assist members? Is how?
Absolutely. As part of our role as a certifying partner, that is something that we assist our members with. We've really upped our outreach to our core holder employers throughout 2020 and ensure that they are well prepared to understand not only what's required for the current year for CORE, but also how we can provide additional support to them. We did take that into consideration, the interview preparation. I think it was brought up at at the last member discussion forum as well. So definitely something that we're working on. It wasn't a priority for this year because this year for CORE, it was a documentation only audit. As we look ahead to 2021, it will become more important to have that, that information available. So definitely something that we're looking at.
Okay, thank you so much. So I don't see any raised hands. Yeah, go ahead, please.
Sorry, Anush, I just wanted to add really quickly too. I know Dana has mentioned it before, but CCSA also put together our integrated toolkit that you can find on our website. I actually put the link in the chat for everyone. So we actually got that everything uploaded in August, and it actually has 3 different sections and all kinds of information, including templates of policies, procedures, forms, educational videos. So again, more areas where our members can reach out, and it's not just our members, it's anyone who goes onto our website.
Yeah, and as part of our collaboration, we have also shared those resources in the Learning Center. So all employees who have access to the Learning Center, they can also access those resources in our system. Okay, moving forward, I don't see any questions besides thank yous and just good comments, which is really, I'm really happy to see all positive comments. So Dana, you want to speak about, I don't know how much time we have, but if you want to quickly speak about these changes.
Very quick, yeah, thanks, Anish. So Tom talked about it as well, but Bill 47, the Improving Workplace Health and Safety Bill, was released last week. And it's anticipated that the OHS legislation changes will come into force in September of 2021. We have posted that information on our website, and I've provided a link to that there on the slide. And so that's basically what I wanted to know. We've posted the information to the Alberta government website, as well as the there's an employer fact sheet that you can access from CCSA's website as well. And we will continue to include information updates on our website as new information becomes available. You can just go to the next slide. The next slide is really about CORE, the Certificate of Recognition Program 2021 relaunch. We had launched a survey to get CORE holder feedback on whether or not they feel they're ready to relaunch a full CORE audit in 2021. And that's just in an attempt to get some information from our membership. Having said that, just yesterday or just this week, Alberta Labour and Immigration and Partnerships has provided us with the final decision. They've been engaging with stakeholders and certifying partners through special meetings about CORE 2021. And as a result of all of that consultation, they have a final decision that's ready to be communicated. So we are just preparing that communication to come out to CCSA members. It should be out no later than tomorrow.
Oh, thank you. Any other questions? I know we don't have a lot of time left, but if you have any questions, please raise your hand or type your questions in the chat box or Q&A box. And while we are wrapping up, so I would like to let all the members know that our next forum is going to be in a little bit different format. We are going to use Zoom meeting instead of Zoom webinar, and all of you will be able to share your screen. So we are anticipating to have a little bit more interactive forum for the next one. It is not scheduled yet, but all of you will receive confirmation as registered attendees on the date and time and how to join the forum. It will happen, of course, in the new year. Okay, I don't see any other questions. Do you have Dana, Nadine, Jeanette, do you have anything to add?
No.
It's Jeanette here from ASCHA, Director of Member Relations, and I really wanted to thank Nadine and Dana for your partnership with us in presenting information and education to our members as well as yours. It really is an excellent partnership. And thank you to the others that presented as well on the occupational health and safety and the new bill. Thank you very much to you all, and I guess you kind of have a 1 minute leeway. Thank you very much.
Thank you very much, everyone.
Yeah, just a quick reminder, please take 2 minutes to participate in our survey, and you all have a great day. Thank you very much for participating in our forum. Bye-bye.